And there's way too many introductory slides here. So, I wanted to really set the scene with some specific advice by talking about the three primary categories that often come up in immigration discussion. And I recognise that all of you know immigration, but there was the question earlier about how do you educate your senior executives? How do you get the message through? One of them is to make sure that you're talking about the right visas. So let's have a quick chat about these ones. A tourist visa. A tourist visa is for tourism purposes. It's not for business meetings. It's not to go and scope a citizen. This one, it's just impressive. It's not for scoping out contracts or anything along those lines. It's for you to be wearing a Hawaiian t-shirt and shorts and walking around the sites. So if you've got employees going to countries for business reasons on a tourist visa, they are almost certainly non-compliant and can get themselves into serious trouble, and you into serious trouble. Short-term business visas. These are the visas where you can attend the meetings, in some jurisdictions undertake training or provide training, in some jurisdictions maintain equipment or scope out contracts and those sorts of things. So a business visa, a short-term business visa, is the correct visa. My area of expertise is Australian immigration law, which is hugely relevant to EMEA, but in that particular environment, that's what's called a 456 visa, so a short-term business visa. But then the next one is the work permit. That's what allows somebody to actually remain in the country, go on the local payroll, and actually work, do productive activity in that country. So in the US context, that's an L visa or an H visa. That's the extent of my US knowledge. In the UK, it's going to be a Tier 2 application or a Tier 1 application. And so work permits, broadly speaking, that's what we're talking about here. Now, the biggest area of immigration risk in any country for any company is the difference between the short-term business visa and the work permit. And this is the message that is often the most difficult to get across to your senior executives, because it's a case of, well, we've been sending everyone into Germany on business visas for the last 10 years, and we've never had a problem with it. Why are you making my life a misery? Or not really working. They're only there to sort of understand the scope of the contract, sit down next to somebody at their desk for 2 months, and gather all of the knowledge and take that back to their country. And I was asked this question yesterday, well, what if we're just relationship building over a 3-month period, and we're gathering information in relation to the contracts, but we're not raising an invoice to the company, so we're not actually charging for what we're doing. Is that work? Well, if that's what your company's doing, you're not doing it to sort of just be nice to somebody and sit next to them for 3 months, because they think that was a little weird. You're doing it because that's what your company does. You build out contract solutions for that particular issue. So when you break it down, that's the essence of your business. So really, an immigration officer is going to say that's work. Whether you're charging for it or not, that's productive activity. Now, I used to do this when I worked in the government, and I would interrogate people. I was really good at it. And so you would break it down into that essence. Later on, my third slide is going to talk about the sort of things you do when you're assessing a business visa. We have a representative here from the US consulate who I'm sure will argue with some of these points that I'm going to raise. But I can, as I'm no longer a diplomat, I can speak much more clearly than I used to be able to. So I will tell you as I think it is as we go through. So we've sort of covered this slide about impact of the recession on the global immigration environment. I keep checking to make sure I haven't looked too far. So we've really covered that with Cindy, sort of scene setting. So let me talk a little bit about some specifics. So there are three primary ways we're seeing the impact of the global economic conditions impact the decision-making internationally. And when I say internationally, we are seeing this right across the board. In my entire career, I have never seen such an environment of coordinated, consistent application of much more restrictive laws in just about every jurisdiction, and some that will surprise you, including, of course, India. I mean, we've seen the changes that occurred and then didn't occur and then reoccurred and then went back again over the last 12 months in Indian legislation. So let me walk through some of this. The first is new legislation. So we're seeing a raft of new legislation right across the board. And some EMEA-specific examples of this is the introduction of the points-based system in the United Kingdom. This is incredibly restrictive and very rigid in its application. There's very little ground on which you can argue, I'm sorry, we didn't understand that, or it was just an innocent mistake. They don't care about that anymore. So the introduction of the points-based system in late 2009, which is actually meant to be built on, based on the Australian legislation, and that Australian legislation I actually wrote when I was in the government. It bears no resemblance to what I wrote. But it does place the onus on the company for enforcement of compliance. And this is a theme that you're seeing throughout the EMEA region, where they're switching, most governments are switching to a form of what's called an attestation system. An attestation system means that you as the company will now attest to certain things in your organisation. So you will be undertaking that you have checked the credentials of your employees, that your employees have valid work permits throughout their period in the country, that you have sufficient controls on your immigration program, you have sufficient controls on your travelling population. Now, it's different to the old days, where if you're an individual, so let's pick you as an example, you went on a business visa for 3 months to scope out and build a relationship with someone. In the past, it was you that would be fined, potentially jailed, although that was unlikely, and removed from the country or deported, and then barred from return. So all of that still now applies to you. But beyond that, because of this attestation system where the company is now saying it has promised to do certain things, you've effectively entered into a contract between you as the company and the government. And so they are going to go after you, the company, for those breaches. So the people in this room who are responsible for the immigration program management are the ones that are on the line much more directly. So let me give you an example. Under the UK system, the authorising officer, who must be a UK national, resident in the United Kingdom, bears now personal legal responsibility for any instances of non-compliance. That can include up to 5 years imprisonment for gross compliance. So you can see that there is a significant impact from these changes. That also sounds great. Well, yeah, trust us, it'll be absolutely fine. But the fine print also says that to reinforce that trust, there will be a massive increase in site inspections and unannounced audits. So they will walk into your business premises and ask to see the work permit status of the employees that are in those business premises. If you then breach that trust by having people who are clearly